10-day online national seminar on National FDP program on emerging trends in intellectual property rights. Let's begin the evening with a silent prayer. Thank you all. Let me now call upon Dr. Hani Sebastian, Associate Professor and Research Guide, Department of Zoology, Vimla College Autonomous Thrissur, to render the welcome to all of us. Ma'am, over to you.
Good
Hani,
evening,
ma'am.
one and all. Yes. Good evening, one and all. Today, on the 7th day of FDP, on emerging trends in intellectual property rights, Dr. Kavitha Chalakal presents a topic on plant variety protection and farmers' right. On behalf of Vimla fraternity and all gathered here, I welcome you, ma'am, to this program. I extend a hearty welcome to our coordinator, delegates, and participants to this much awaited session. I feel honored to introduce our resource person, Dr. Kavitha Chalakal, Assistant Professor in Inter-University Center for IPR Studies, Cochin University of Science and Technology, Kochi. She has more than 12 years of experience in the field of academics and worked in various national and international non-government sectors. Dr. Kavitha completed her PhD in International Environment Law from JNU, New Delhi in 2014. She has many publications in her credit and presented research papers in various national and international conferences. She is a recipient of the Best Paper Award in 2 international conferences. She is a member of the World Commission on Protected Areas, World Commission on Environment Law, and IUCN, International Union for Conservation of Nature and Natural Resources. Dr. Kavitha was a Fox Fellow to Yale University, USA in 2009-2010, and she has a research association with China South Asia Legal Research Center, China Law Society. Once again, hearty welcome, Kavitha ma'am, and all participants. Thank you all. Have a fruitful session ahead. Thank you.
Thank you, ma'am, for the kind words of introduction. And good evening and welcome to all participants. I'm like when we were fixing the time, I was telling Sylvie sister that maybe that evening time would be a difficulty for most of the participants because all of us are working. So the whole college day work and evening at home also you are into work. But still, I'm so happy that we were able to conduct this 7 days FDP, and I'm sure almost all sections were very, what we say, informative, and at the same time might have helped you to gain a lot of knowledge. So let me just start with my presentation. Uh, is the screen visible? Can anyone let me know?
Yes, visible, ma'am.
Yes, it is.
So today we are going to talk about protection of plant varieties in
Ma'am,
India.
it is not in slide mode, ma'am.
Okay, just a second.
Yeah.
So today I'm just sharing it with from a tab rather than from the word. Just a moment. Yes.
Yes, okay, ma'am.
Yeah. So today we will be discussing plant variety protection of plant varieties in India, and how that entire legal system or that particular law came into existence. So we can see that a plant variety is a plant grouping within a single botanical taxon of the lowest known rank, defined by the expression of the characteristics resulting from a given genotype or combination of genotype. The variety should be distinguished from other plant grouping by expression and should be considered as a unit with regard to its suitability for being propagated and unchanged. I'm not going into much details about these things because I'm sure most of the participants know more than me with regard to what is a species, what is a genus, what is a kingdom, etc. So here, what I would like to tell you is that the law was made in the context of creating new varieties which would be higher yielding from one perspective, and at the same time the farmers are also to be protected. So you all know that within a single species there can be multiple types of plant, and each of these types of plants would have their own impact. So when we have a plant kingdom, we have the species created, then we have the varieties within the species. So these images are very simple images, I know, for microbiology or botany department, but this is what we understand, make common people understand from an international point of view to understand what is kingdom, species and variety. So the question is, why do we need to protect plant variety? Till yesterday, you have very clearly studied about things which were the creation of your intellect. Now we are talking about something which normally shouldn't fall under the regime of intellectual property law, but we have been forced to an extent to give that protection. So basically, the protection provides for two or three categories of people are protected: breeders, farmers, and other stakeholders are protected. Now, why are they needed? Why do they need to be protected? Those who are working with agricultural university or those who are in this process of developing new varieties of plants would know that the effort you have to put into the development or creation of all these varieties are immense, and your intellect and your labor is vested in those things which you are planning, which you are creating, or which you are what we say breeding right now. So the law says that it needs an intellectual property protection. So let us be a bit cautious about this approach, because the initial demand for IP protection, that is intellectual property protection for plants, did not come from farmers. It basically came from multinational companies who were developing more and more types of seeds. So these seed companies, for example, Monsanto or Nussweeder, all these companies have a lot of varieties coming up, and they want to protect their newly created varieties of plant. And they say that if they are given a protection for their investment, they have a better incentive to invest more, to create more. So basically the commercial plant breeders are encouraged to invest the resources. So this particular this particular law is capable of directly affecting our food security. Now, food security, you know that India in the 1960s and 70s, that is immediately after our independence, we were facing high poverty, high level of population, and less resources. So, you know that the impact of Green Revolution or White Revolution or the Blue Revolution, all those revolutions had in our country basically ensured that we had the food security, health security, etc. Now, uh, when we are talking about plant variety protection, this also came from a World Trade Organization bunch of agreements. So there is one agreement called, I'll be coming to that just a bit into the discussion. So this international legal system stated that plant varieties are to be protected, and very crucially, you need to remember it was the MNCs which pushed for the protection of these seed varieties. So the international law said that you can protect them in three modes. One is giving them a patent. So in the first class and the third class, when you studied patent, you know that patents are given for any type of product or process. And it requires the three criteria to be fulfilled, that is novelty, inventive step, and industrial application. So the international law said that one way is to protect it through patent. Another one is give it an effective sui generis system. Sui generis is something which is unique to your own domestic situation. So TRIPS did not define, TRIPS is trade related intellectual property rights agreement, which is under the WTO. So the what we say, it was given to the flexibility was given to the the countries to offer either a patent or a sui generis system or a combination. So many of the developing countries have adopted national legislations and they complied with TRIPS by providing the protection. So either you give a patent or you give a type of protection which is most suitable for your country, or you give a combination. That means you are giving both patent and a plant breeder rights. Now, India opted for a sui generis system. We did not opt for a patent system. There are certain countries which is giving both. For example, US gives both patent and breeders' right. So, in India, plant variety protection is done through an act called Protection of Plant Varieties and Farmers' Right Act. This was enacted in 2001. And it states that the purpose was to give protection, as the name indicates. The purpose was to give protection to both plant varieties on one side and farmers on the other side. And this was based on the particular article 27(3)(b) of TRIPS, which said that members shall provide for the protection of plant varieties either by patents or by an effective sui generis system or a combination thereof. That is what we discussed just before. Now, the reason which is stated behind such a provision in that international agreement was because there was a tussle and conflict of opinion between the US and the European Union. European Union is more welfare in context, even though they are all developed. Most of them are developed countries and more capitalistic in nature. They have this welfare democracy in their ideology. So they were more of the option that it should not be patent, because patent gives a high level of protection for 20 years and the farmers would not be able to access the things which are patented. So they said that the purpose of this act is to benefit society and should be to develop agriculture and forestry, etc. And it should, EU stand was that it should establish an effective system for protection of plant varieties, the rights of farmers and plant breeders, and also to encourage the development and cultivation of new varieties of plant. So accordingly, our act was enacted, and the first objective of the act was stimulation of investment for research and development in public and private sector for the development of new plant varieties by ensuring returns on such investment, promotion and growth of the seed industry through domestic and foreign investment. Thirdly, recognition of the role of farmers as cultivators and conservers and the contribution of the traditional, rural and tribal communities to the country's agro-biodiversity by rewarding them for their contribution through benefit sharing and protecting the transitional rights of the farmers. So what we need to remember is that even though we are in the advanced stage of developing country, India in its independent stage, from its beginning, we have always relied on agrarian economy for our existence. So creating something new, which would take away all those farmers' rights, or which would take away the farmers' right to cultivate or farmers' right to harvest or any of those things, you can understand this is a bigger problem and there would be an opposition for it. So the purpose, even though the first two purposes, I would say that is the ideal of the main objective, because it is basically for the keyword is on investment. You can see that both the objective are based on investment, but the third one is also not less important in the scheme of the whole thing. And the act gave protection to the farmers also, and they were recognized for the role in the contribution of the traditional rural contribution to the traditional and rural and tribal communities, and also how much they are giving into the agro biodiversity. So you cannot create a plant varieties act without considering what happens to the farmers within that particular economy. And the act establishes an authority which is known as the Protection of Plant Varieties and Farmers' Right Authority. And basically, it has major functions of promotion and development of new varieties of plant and rights of farmers and breeders. It provides for registration of new plant varieties. It helps in the characterization and documentation of varieties. It gives compulsory licensing of protected varieties, and it uh, gives collection, compilation, and publication of plant variety seeds and germ plasm. So before we move on to the further provisions of this particular act, I want you to look into the. Ki Amuta, do you have a query? So this is the official website of our plant variety protection, and you can see that it has a lot of details in that. So you can basically get all the information like the DUS centers, which we will be discussing in bit of detail, your application details. So basically this gives you the details of plant variety protection existing as of now in the government. So I would suggest all of you, because both or most of you are from the botany background, I would suggest all of you to at least visit this particular website once, or today or after a presentation or something, and then look into the functions of the authority. So here we can say that the particular authority is entrusted with the task of ensuring the plant varieties are given adequate protection. And as I said earlier, farmers were not very happy, or the entire community, NGO, civil society, most of them were not very happy about the entire bill, because it's for the first time you are introducing something which is going to regulate the farmers or the common public from what to sow, what to harvest, what to use, etc. So the government proposed that it's not just protection we are offering, we are actually giving them certain set of rights. And the government position was somewhat understandable also, because MNCs are creeping into the seed economy, and it will be very difficult for the small scale farmers to fight against them. So they said that the particular act is going to give these sets of rights: the right to save, exchange, and to a limited extent sell seeds and propagate material, to register their varieties, to recognize and reward for the conservation of varieties, to benefit sharing, to information about expected performance of a variety, compensation for failure of variety to perform, availability of seeds of registered variety, then free services, it's only for farmers for registration, conducting tests on varieties and other legal claims under the Act, and also protection from infringement. One of the major factors which we need to understand is that these days, at least in Kerala, I know that because my family also have paddy cultivation, we usually get the seeds from the Krishi office. The Krishi Bhavan gives these seeds. We have to purchase it for price. And it is a particular limited quantity per hectare which is given to you. And you are required to cultivate using that seed which is made available to you. Now, the question is, if the farmer who has stored seeds from the last harvest, would they be allowed to sow the seeds in their next season? So in my in a personal experience, we found that the krishi but we say that agricultural officer was very much against it, and they wanted us to cultivate a particular seed which we opposed. And it was a big issue in the sense that we were said that our crop insurance would not be completed. It was basically terms of threatening, when the Plant Variety Protection Act has given the right to farmers to use the seeds which he had cultivated from his previous season. So these are the rights which would not have been available with the farmer if this particular act has not been done. However, as any regulatory act, this act also restricts the farmers from protecting their variety. We know the Indian agrarian economy, and we know that how many of these farmers are aware of this Plant Variety Protection Act. How many of them are capable of convincing the we convincing them is a bigger issue, because farmers don't believe in private appropriation of property. The traditional farmers in India, they believe in sharing. You ask a farmer for some seed, they wouldn't even ask for money, they would give you the seed. So we had a tradition or a culture of sharing our resources, and suddenly there is a law which says that you are not allowed to share it anymore. You need to follow the pattern of your pattern which is given by the act. This essentially creates a problem for the farmers, and most of the time this is affecting mainly the small scale or the what we say small landholders, farmers. Now, when we talk about creation of new plant varieties, we have the traditional breeding method which is used, and that employs processes that occur in nature such as sexual and asexual reproduction. However, the resultant plant emphasize on certain characteristics. But you know that they are not technically new. They are not technically new because the new variety would be showing the essential characteristics of the previous variety also. Then you may create new one through genetic engineering, where the process does not occur in the nature, and you, biotechnology and microbiology has contributed a lot to into this. So you insert genetic material into a particular plant's genome, which need not be present in the original species, or altogether you create a new genetic material, the expression of which leads to new plant characteristics. So the question is this new through genetic engineering, the people who are into botany, who are into biotechnology, would know how expensive the whole process is. I can easily say it, but the process is highly expensive, and it is not possible for a normal farmer to take up the genetic engineering. So, when we are having this Plant Variety Protection Act, we need to understand that this is basically going to protect those who are investing that money for it. And at the same time, you cannot disappoint the farmers, so you are offering them another set of rights. Now, the Plant Varieties Protection Act actually protects what we say four categories of varieties. They are novel variety, or the what we say the new variety of seeds. Then we have the extant variety, then we have the farmers variety, then we have essentially derived variety. So the new variety is a variety which is not in public domain in India earlier than 1 year before the date of filing, or outside India in the case of trees or vines earlier than 6 years, or in any other case earlier than 4 years. So I think you are familiar with the term public domain. Public domain essentially means the resources which are freely available for almost everyone in the community. So a new variety is essentially that variety which does not have which is not in public domain at least 1 year before the date of filing, or in the outside Indian case of trees and vines not earlier than 6 years, and in any other case 4 years. On the other hand, an extant variety means a variety which is notified under the Seed Act. India has a Seed Act also in 1966. So extant variety is basically a variety which is notified under the Seed Act, and or a variety about which there is common knowledge, or a farmer's variety, or any other variety which is in public domain. So anything which is existing, which has been recognized by the Seed Act 1966, is known as an extant variety. And then we have the farmer's variety, a variety which has been traditionally cultivated and evolved by the farmers in their fields, or a variety which is wild relative, or a land race of a variety about which farmers possess common knowledge. So farmers' variety is a variety which they have been cultivating, they have been traditionally cultivating, and they have been evolving it. And essentially derived variety is a variety which is essentially derived from the initial variety, where it is predominantly derived from what we say while it is derived from an initial variety, and when it is evolving, it retains the expression or the essential characteristics that result from the genotype or a combination of genotype of such initial variety. And this essentially derived variety should be clearly distinguished from the initial variety. And this particular EDV, that is essentially derived variety, must conform that it is the result of the previous variety. So you are deriving a particular variety from an initial variety, which is different from a new variety, because a new variety could be an EDV, but a new variety is only considered as a new variety if it is not in public domain earlier than 1 year before the filing. So basically, it can be seen that these four categories, four types of varieties are given protection under the Plant Varieties Protection Act. So they give, like, in the initial stage, they give protection for cereals, legumes, fiber crops, etc. In the third phase, they gave sugarcane, ginger, and turmeric. And in the fourth phase, they have recognized oil, seeds, fodder varieties, vegetables, flowers like rose and chrysanthemum. As of now, that is as of July 31st, there are 5,285 certificates issued crop group wise. And among them, 3,507 cereals are there. And you can read the rest of the numbers. So there are 12 flowers which are being protected. And as I had shown in the previous website, the entire registry is open. So you can identify the species with their genus and everything which is protected under this. So as of now, we have 5,285 plant varieties protected under the Act. And among them, most of the category which is right now protected is farmers variety and the extant variety which is already known. So the new variety and the essentially derived variety is comparatively new variety is comparatively smaller than both all of them combined, and essentially derived variety is very less. It is very minimal as of now. So basically, to get a plant variety protected, it should qualify four categories. In case of a new variety, it should qualify the term of novel. So novelty means newness, something which is new. So a plant variety is identified as the novel if at the date of filing of application, the propagated or harvested material of such variety has not been sold in public or otherwise disposed with the consent of the breeder or his successor. So this is basically what we said earlier. To identify as a new variety, it should not be available in the public domain earlier than 1 year from the date of file of application. And then we have the next characteristic, that is distinctiveness. Distinct. A variety should be distinct to get a protection under this particular act. I would like you to remember your copyright classes or your patent classes, where you learn that patent is available for novel, a new inventiveness and commercial utility. These three criteria are to be fulfilled for you to get a patent. A trademark should have a distinctiveness and it should be graphically expressed. A copyright is only given for an expression, not for an idea. So similarly, these four characteristics are the characteristics which are required when you are giving protection to a plant variety. So the distinctiveness basically means the variety is considered as distinct if it is clearly distinguishable by at least one essential characteristic from any other variety whose existence is a matter of common knowledge. So there are so many mango varieties, and you are going for the protection of a particular type of mango variety. That variety should have at least one essential characteristic which is distinctive from the existing mango. It could be any characteristics. For example, it could be the ripening time, it could be the color of the mango, it could be the size of the mango, but it should have a very distinguishable essential characteristic from the existing varieties. Third one is the uniform nature of the plant variety. So we all know that at times, even if we, when we we may I use the term borrow, but sometimes when we go out and we see a very beautiful plant and we cut the plant and we come back and we try to replant it, sometimes it might not give the same flowers it had in the previous instance where we had seen. Or sometimes it may have one time it may have the same flowering pattern, but in the next season it may not be like that. So when you are going to get a plant variety protection under the law insists that it should be uniform. I mean, it's not uniform in that sense because there are a lot of factors which are affecting the plant variety and its existence. So uniformity is basically subject to the variation that may be expected from the particular features of propagation. That is a condition. It is sufficiently uniform in its essential characteristics. Some of us know that when we see a beautiful bud rose, and if we cut a branch and if we bring it to our home and we make it, the first flower may come out as it is. But if it does not perform in its second flowering season, or you give a piece of stem to someone and they try to plant it but it never flowers, that is known as ununiform or non-uniform pattern of a particular variety. Law says that for a plant variety to get protection, it should have a uniformity. And then the third factor it should be having is it should be stable. The stability indicates that its essential characteristics remain unchanged after repeated propagation, or in a particular cycle of propagation, or at the end of such cycle. These are mandatory, compulsory, these are mandatory in the sense that this DUS is important for all variety, and novel variety that novel standard is important for the new variety. Unless you are able to prove all these 4 points or 3 points as applicable to the variety you are going to register, you may not be successful in getting your plant variety registered. So I have spoken about what type of varieties are registrable, but what we need to understand is that there are certain categories which are not registrable in India. So I think we will be coming to that in the what we say next slide. So are you clear with what we have reached till now? I mean, it is slightly different from the previous categories of IPR which we have understood. So basically what I was saying in case of novelty, that to prove novelty, it should not have been available in India outside 6 years or 4 years. And when you use like a particular plant variety is developed after a series of what we say trial and error method. So just because you used a variety for trial doesn't mean that its novelty has gone. The novelty is still decided by whether it is sold or disposed in India for last 1 year, and outside India 6 years and 4 years respectively for trees and vines. So what this we just discussed, but let me just add one point clearly here. In case of a farmer's variety, you are supposed to register within 3 years. So that is another restriction they have put on the farmers, because it's not easy for the farmers to understand the entire procedure and get it registered. So as I said earlier, all plant varieties cannot get legal protection in India. Certain plant varieties are excluded from the protection under PVP Act 2001. So where, if your particular seed is going to be against public order or public morality, or human, animal, plant life or health, or it may create a serious prejudice to the environment, in such cases, the variety might not be protected by the Act. Because if it is against public morality, or if it is something which is against the human, animal, plant life, so for example, we have this cannabis or certain other plants which are sort of which could be used for creating drugs or other narcotic drugs. Those cultivations are not permitted, and you are not going to get a protection for that particular category. This is against public morality or public order. Or there are types of plants which are what we say, which may create serious prejudice to the environment. There are certain categories of plant which use groundwater in an alarmingly high level, or some varieties such that it might not get registered. So similarly, I have just shown you the official website of our what we say, the plant variety protection. So you know that right now they only protect cereals, fiber crops, vegetables, oil seeds, legumes, fruits, sugar crops, spices, trees, forest and plantation crop, flowers, and medicinal and aromatic plants. So there are multiple categories which are outside the scheme of protection as of now. So these categories are not protected. The next question is, who can apply for the protection of a variety? Any person claiming to be the breeder of the variety, any legal heir or successor of the breeder of the variety, any assignee. So if it is a breeder, it could be his successor, or it could be his assignee, that I'm giving the right to. So for example, in government universities or the private universities, where a particular faculty member might have come up with a new variety of seed or new variety of plant, it may be the application may be going in the on behalf of the name of the institute in which they are working. Similarly, if a scientist who is working in a seed company is creating a new variety, the protection would be given. I mean, the protection, the plant variety application can be started with that assignee, that would be the investor or the company itself who would be the assignee. So you may be known as the inventor of that particular breed of plant, but the right would vest with the assignee, that is most probably the company which is paying you to create that particular variety. And the second category of applicants can be any farmer or group of farmers or community of farmers claiming to be the breeder of variety. So that is farmers. And then any person authorized in the prescribed manner by the persons mentioned above. So a breeder and a farmer can specify someone to apply on their behalf. And then you have the university or publicly funded agricultural institution claiming to be the breeder of the variety. So this is basically who can apply. And when we are filing for the registration of plant variety, we need to give the set of details. For example, name, address, and nationality, denomination of the assigned variety, and required, what we say, affidavit which says that it does not contain gene or gene sequence involved in terminator technology. And you have the data of the parental lines with its geographical location in India. And if it is taken from any other farmer or any other village community, institution, or a traditional tribal group, you need to recognize that also. And you have to give the characteristics of variety with the description of novelty, distinctiveness, uniformity, and stability. And you also need to give a declaration that the genetic material used for breeding of such variety has been lawfully acquired. This particular clause is to prevent the situation where biopiracy is happening without without any ethics or morality, where the people have been stealing the traditional knowledge of these farmers and using them to create new types of plant. So we have to, once you apply an application for registration, the application goes through two stages. First, all applications are received at the authority and they compile and publish it on the website. And second, those varieties which we discussed earlier, which had DUS, that is distinctiveness, uniformity, and stability, are again published in the Plant Variety Journal of India, which is published by the authority. And then if any farmer, any breeder, or any person who has an interest in that particular plant variety may put forward any objection for the registration of that particular variety. So it is the task. So most of the time there are NGOs which are working with the farmers, NGOs which are engaged in this activities, which create these types of which is always cautious on how these particular type of varieties are being registered. And I mean, if I am identifying a potato variety which is high yielding or which gives you softer potato when it is cooked, I know who else is continuing their potato research. So I would always keep an eye on whether their application has been published in this plant variety journal also. So the publication is basically one option on which we as general public or the person who is interested can oppose the registration of that particular plant variety. So once a variety is registered, that is, again, it has to complete the DUS test. There should not be any objection. And once it is done, this particular variety would be registered. And once it is registered, it is advertised once again in the Plant Variety Journal of India as a registered variety. So the purpose here is basically to ensure that the farmers know where their seeds are or who are protecting their seeds. So this publication permits the stakeholders to understand the status also. And most of the time, the certificate is issued within 3 years after filing of the application for registration of the variety. And as per the law, as per section 24, you have the duration for trees and vines, 18 years from the date of registration of the variety. For any other crops, 15 years from the date of registration of the variety. For extant variety that is already existing in the public domain, you get 15 years from the date on which that particular variety was published in the Seeds Act 1966. If you are getting a feed registered, we need to understand that this deposition is necessary for DUS test conducted by the PPV and Plant Variety Protection and the Farmers' Right Act, and they need to deposit the fixed amount of seed for propagating the material with prescribed germination percentage, physical purity, and phytosanitary standards, along with the seed quality test report to the authority. Once you are registered, we will come to the exemptions later. Once we are registered, the rights of the owners of the varieties are given as follows. The owner has the right to produce the protected variety, sell the protected variety, market the protected variety, distribute the variety, import the variety, and export the variety. In case if the variety is an essentially derived variety from a protected variety, then you require an authorization from the initial variety to market your essentially derived variety. So essentially, you can see that the protected person, the rights of the owner comprise basically of the commercialization of the protected variety, including producing, selling, distributing, importing, exporting, etc. And in case, like you have given, and we have seen that it is 18 years, etc., for the protection. In case the protected variety is not available in the market, you have this concept of a compulsory licensing, which you might have discussed in the patent class. I also have discussed it in that Bayer case, Bayer Corporation's case. So here, if the seed of a protected variety are not available even after 3 years of registration, in adequate quantity or at a reasonable price, the authority may grant license to a third party to undertake production and to distribution and for distribution and sale of the seed on a reasonable royalty. So in case, like, if your seed is not, if I protected a particular type of variety, but I'm not marketing it for the next 3 years even after registration, and even when I'm marketing, I'm not offering it in adequate quantity or at a reasonable price, then the authority under section 3 can take away my right and give a compulsory license for someone who is capable of making that seed. Now, in the previous slide, we studied this, we saw these rights of the owners. If any one of them does anything which is given to a owner without the owner's permission, we call it as an infringement of the right of the owner. So in relief in case of infringement is that you have an injunction. Injunction is a stay order against the infringer, and the plaintiff, like the person who is claiming that particular injunction, can also ask for profits and damages from the infringer. So what constitutes infringement? Basically, if the person who is not a breeder of a variety registered under this act, or registered agent or a registered licensee of that variety. So basically, someone who does not have the right under the act. If I have registered the variety, the right belongs to me. No one else would be having that particular right. So if someone other than me is going to sell, import, export, or produce such variety without the permission of its breeder, or within the scope of the registered license or registered agency without their permission of the registered agent or license. So in that case, it is known as an infringement. So anyone who doesn't have the right for that particular plant variety or seed variety, if manufacture it, it is identified as an infringement. Similarly, if a person sells, exports, imports, or produces any variety, given such variety, the denomination is identical with the variety already registered. So it need not be the same variety. Something which is identical also, because it causes confusion in the mind of general public in registering, in identifying the registered variety. So you are not allowed to deal with something which is already registered in the under the act, and also some other variety which may confuse the purchaser with the registered variety, which seems a bit over the top when it comes to the farmer's right. So earlier I said that there are certain rights which are not to be considered as infringement. We have majorly two categories. One is the farmer's right and the second one is the research right. Researcher's right are comparatively smaller, so I'll just discuss that and we will go back to the farmer's right. So researcher's rights means if you are using a variety for research and experimental purpose, it is an allowed use. It is not a violation of the right of the breeder or the farmer who has already registered. If you use a variety as an initial variety for the creation of a new variety. For example, you are getting an essentially derived variety, but every essentially derived variety has an initial variety which could be registered. So if you are using a particular registered category for ensuring the creation of a new essentially derived category, you can use it without it is not identified as an infringement. However, please remember that repeated use of the variety for commercial production of a new variety is not allowed without the authorization of the breeder of the registered variety. Now, when we talk about the, before we go for that, let me just start with the breeder's duty. When we see that the breeders are given a particular category of rights, and in all circumstances, the breeder is supposed to give the correct and expected yield or performance of the particular product under a given set of conditions. And then there should be a disclosure from the breeder with regard to the explicit and detailed disclosure about the parentage of the new variety. And again, the breeder has the responsibility to ensure that the denomination of the protected variety conformed with the description of the protected variety. So one thing is that you need to give a disclosure, and in that you need to give exactly or not exactly correctly the expected yield or performance. And then it needs to be ensured that the seed which you are submitting, the plant which you are evolving is similar or meets those disclosure which you have given at the time of your application. And another most important responsibility of a breeder is that a breeder should not use terminated technology within their gene. So I'm sure you would be very clear about what are these terminated technologies. I'm not from a science background, so let me, it's like VGURT, that is variety level GURT, gene use restricting technology, and trait level GURT. And VGURT causes the seeds of the affected plant variety to be sterile, in contrast to the TGURT, which result in the expression of a selected trait. As per the law, both these are not permitted. The seed company is not allowed to use any type of GURT, that is gene use restricting technology, in their seeds. And there is a protection against innocent infringement. Sometimes the farmers might not even know that they are infringing the breeder's rights because they are not used to the new situation. The law allows them for protection from prosecution for innocent infringement. And in next is benefit sharing. If you are using, it's something which has been introduced under this particular law. If you are using a variety of a particular, existing variety or an initial variety, you need to give a share of your benefits or the profits which you are creating from that variety, and it is usually deposited to the gene fund. And they are when you are using a plant variety, the registered breeder has to pay the conserver of the plant variety the genetic material of which is used by the breeder in evolving his new plant variety. So for example, in Kerala, we have this particular category of rice called Pokali rice. Pokali rice is very tall and it can have a good yield even in saline water. Usually paddy is freshwater cultivation, but Pokali is a variety which would grow even in saline water. So if I am using this particular category of paddy, for example, in Orissa, in the saline areas of Orissa, I have to ensure that I am going, if I'm going to develop a variety like that, as a breeder, I am responsible to give the conserver of that particular plant variety an amount which is for the genetic material. Here, the beneficiary is the person or persons who conserve the plant varieties. So there are certain types of wild varieties which are preserved by certain type category of tribal groups or farmers. So whenever you are using those varieties as an initial variety, or when you are using that material, you are supposed to pay back to the person from whom you are taking it. And there is a clause protecting the farmer from using the spurious seed or least too much to the discretion of the authority. So, however, even though there is a protection against bad seed, there are there is no specific guideline which the authority gives. It's up to the breeder. And I'm sure those who are into paddy cultivation, sometimes we suffer from the situation where the seed doesn't germinate. Half of the seed doesn't germinate, and when we go back to the krishi officer, the agricultural officer, they would say that you did not follow the step exactly as we had insisted you to do that. So yes. So what happens is that these type of instances require more specific guidelines from the authority. And similarly, it also offers penalty under section 71 and 72 and 73, where if someone is using your variety without your permission, or false denomination is applied, etc., you may get a you get a remedy from the judicial system under the act. So now we are going to the one of the major topics of today's discussion as to farmers' right. So who is a farmer? A farmer is defined under the act as a person who cultivates crops by cultivating the land himself, cultivates crops by directly supervising the cultivation of land through any other person, conserves and preserves severally or jointly with any person any wild species or traditional varieties, or adds value to such wild species or traditional varieties through selection and identification of their useful properties. So farmer could be a person who is directly cultivating the land himself, or someone who is supervising the cultivation in his land, or someone who preserve the rights. Now, apart from the research rights or the research exemption given under the Plant Variety Act, you have a set of rights given under section 39, that is farmers' right. This is a very important set of rights because this is the crux which forms the crux of the particular legislation. So here it says that a farmer has the same privilege with respect to a breeder of a variety. And a farmer's variety shall be entitled for registration if a declaration has been made that the initial variety has been lawfully obtained. A farmer can save, use, sow, resow, exchange, share, or sell his farm produce, including seed of a protected variety. That was one of the main concerns when we had this particular enactment. Will farmers have their seeds? That was a major question. Will they have the seeds? Because if they are not getting the seeds, how will they cultivate? If they are not cultivating, what about the food security? What about their livelihood? So, what we say, if it is not, of course, a branded seeds, you cannot buy branded seed and resell it. But then, whatever you have created in your own farm, you can use, you can save, you can sow, you can resow, you can exchange, etc. But please remember, these rights are only available for farmers, and farmers have been already explained in the previous slide. Someone who cultivates, someone who supervises the cultivation, or someone who is conserving, preserving, etc. And similarly, a farmer can claim damages if the seed of the protected variety does not give the yield as stated by the breeder. Farmers have the right, have that right to claim compensation if their seed is not performing well. And the Act also provides the farmers against unintentional and accidental use of protected variety. That means there is no infringement if the farmer was unaware of the existence of the right. And if the even if you have a damage against a farmer, a damage is sort of a compensation. You need to pay a certain amount of money as damages. So if the farmer is able to prove that when he used that particular variety, he was unaware of the existence of such right, and then you cannot ask the farmer to pay the compensation. So basically, it is a protection against unintentional use. And they are exempted, or a farmer or a group of farmers are exempted from paying fees in any proceeding, including any fee payable for inspection, or for obtaining any copy of a document or a copy of a decision. So essentially, the Act tries to balance the breeder's rights and the farmer's right. So the Act acknowledges that the role of rural communities as contributors of land races and the farmer varieties in the breeding of new plant varieties. So basically, when you are coming up with an essentially derived variety, you are mandated to take the permission from the initial variety farmer from whom you are going to essentially derive this particular variety. So, a community's claim can be registered uh, at the notified sender, and if an essentially derived variety is using a particular community's protected, the traditionally conserved preserved variety, they can ask for profit, and this profit will go into as I said earlier, a national gene fund. So basically it is only for Indian citizens and organizations, and this is basically used for improving the condition of the farmers. At times it is given to farmers groups, at times it is given through government system, but the National Gene Fund would give you the would give some sort of benefit which is shared by the farmers. And the penalties, which I said earlier, 71 section 71, 72 and 73, it may range from 50,000 to 10 lakh depending on the uh, or you may have a prison time from 3 months to 2 years depending on the damage caused. And if you're having a repeated offense, like you have been caught once, then you are doing it again, your fines may go up to 20 lakh and a jail term of up to 3 years. So thank you. I rushed through this particular presentation because I had exactly 1 hour. So we need to have some time also for the questions. Any questions?
The forum is now open for discussion. Anybody, any questions? Dr. Amuda has her hands raised, ma'am.
I think she has
Kavita,
raised
ma'am?
it from the beginning, ma'am. Renali,
Okay,
ma'am.
all right.
It might have been a mistake. I think Issa Senthil Kumar has raised it. Like,
So you may ask your question.
Thank you very much, madam, for your nice presentation. But because this is one of the very important session,
yes, sir. Yes, sir.
a few clarification from my side. You know that the multinational companies protecting laws for their new varieties,
Yes.
especially the seed varieties,
Yes.
the terminal, the technology, whatever that you mentioned,
Yes, sir. Yes, sir.
which affects agriculture, especially the small farmers.
Yes.
That leads to many suicide attempts in the country, as you know it, very
Yes.
long, right?
Yes.
Because which affects the food security of the country.
Yes, sir.
But certain European countries granted limited protection to breeders to exclusively market the seeds.
Yes, sir.
But what's the status in India? Whether we have any such protecting laws for the such breeders variety to protect the small farmers?
So what we can see in the Plant Varieties Act is that the government has tried to protect both breeders and farmers within its ambit. If it was protected through patent law, none of the farmers could have got a protection in that, because to get a patent, you need to prove its novelty, inventive step, and commercial utility, which is not possible for the farmers to prove. And these varieties are only different with 1 or 2 essential characteristics. So Europe follows both. EU and US gives both patent rights to the breeders, and their farmers' rights are also protected within other legal system, other regulations. In India, we are not economically developed to that stage. So we have a limitation when it comes to our when it comes to our farmers and their protection. But bigger than that, our main concern was ensuring these food security to the Indian population. If the farmers' rights are not recognized along with the breeders' rights, then the availability of because livelihood is essentially, as you said, vesting with the small scale landholders. The WTO system, through its agreement on agriculture, agreement on subsidy, and trade facilitation agreement, various international agreement, has substantially reduced the amount of food resources you get through ration shops. You may have seen a steady reduction of things available through our ration shops. Our public distribution system, which was modeled in the Russian PDS, is now coming low because we are following the commitments we have towards the World Trade Organization. So our subsidies have come less, our ration shop materials have come less. So essentially, the small scale farmers are suffering for their or are affected with their livelihood. And only vesting breeders' right, which would have been done if it is in patent, would essentially or very adversely affect the small scale farmers. So, what India has done within the scheme of this act is that it has given protection to breeders. New varieties are protected. It is giving protection to extent variety and farmers variety. Farmers are protected, communities are protected. Essentially, derived variety could be from the farmer's side or from the breeder's side. So, by expanding the scope of protection or the comprehensiveness of these categories of seeds or plants which are being protected, Indian law has tried to balance both these rights within a single system, within a single law, that is Plant Varieties Act. That is why we call it a sui generis act. So we have hailed our act as something which is suitable for the Indian domestic agrarian economy system. So, but on the other hand, breeders would prefer a patent law because patent gives them a stronger protection, patent gives them a longer duration of protection, and the rights which you get in patent is high compared to the compared to the plant variety protection you are currently getting. But then, if you don't give this protection under this particular law, farmers' rights are going to be affected. As I had discussed, innocent use of the farmers have been excluded, research exemptions are there, which is not, innocent use is not so easily excluded under the patent law. So we have tried to balance it, but EU has a more advanced legal system when it comes to the breeders' right because they offer both patent and farmers' rights. Dr. Senthil,
Thank you very much, madam.
thank you, sir. Thank you, sir.
Yeah, thank
Dr.
you, thank you,
Velmala
ma'am.
Madhu. Dr. Velmala Madhu, is there a call?
Dr. Madhu, you may ask your question now. Dr. Madhu, you may ask your query now. I also remind all the participants present here to fill out the feedback form, which has been posted in the chat box as well as in the WhatsApp group. And the feedback will have to be given for all the 7 days of the National FDP. So please do access the link and complete your feedback, which is mandatory for certificate distribution. Dr. Madhu, shall we have your question? Am I audible, ma'am? Kavita, ma'am?
Yes, you're audible, ma'am. I think it might have been a mistake.
Thank you.
Ma'am.
Thank you so much.
Yes.
All right. Okay. I once again remind all the participants to fill out the feedback forms, the feedback links, which are posted in the chat box, as well as the WhatsApp group of the participants. So please do go ahead and fill the feedbacks immediately. I suppose Dr. Madhu is not there. Anybody else? Any other clarification? Raji ma'am, do you have a question? You may please unmute and ask the question. Dear friends, we'll begin our valedictory function in a short while from now.
So, ma'am.
Thank you, Kavita ma'am, for a
yes,
beautiful
thank you so
and
much,
enlightening
ma'am.
session.
Yes.
It was indeed very perspective of
I'm sorry it was
IPR.
fast because usually it's like a 1.5 hours.
We shall be waiting henceforth for the guests to join us, after which we shall immediately move on with the valedictory. Anybody else? Yes, ma'am. Continue. Please continue.
So thank you, everyone. It was wonderful interacting with all of you. This is actually a slightly longer session. I was planning it for Saturday, but I was not able to take on Saturday. if you have any queries, I have give like my ID and I'll just share my email ID with you in case you need.
Ma'am, Dr. Clint Anthony has also raised his hand.
It has been raised for some time, ma'am.
Shall we have your... Okay, okay.
So this is my contact details in case you need any clarification on any things which we have discussed in the last couple of days. Please let me know.
Dr. Kavita has given her number in the WhatsApp chat. All those who would like to contact her and clear your doubts may please take down the number. I remind all the participants present here once again that the link for the feedback has been posted in the WhatsApp group of the participants as well as the chat box. You may please access it to mark your feedback for all the 7 days of the FDP. So please continue to do that while we wait for the valedictory function and Dr. Sabu Thomas to join us. Thank you so much.
Ma'am, may I keep my video off now? Mrinalini ma'am?
Yes, ma'am.
Yes.
Sure, ma'am. Sure, ma'am. Go ahead.
Thank you,
Please,
everyone.
please.
Thank you once
Thank you.
again. Thank you to Dr. Sylvie Matthew and other organizers of today's event, Sister Jean also. Thank you so much. So I'll be thank you, everyone. I'm so happy to see that all 80 of you were till there towards the end on the 7th day, which is not a small effort. Congratulations, everyone, on completing this course successfully. Thank you so much. And thank you, everyone.
Thank you, madam, on the behalf of the participants. Thank you very much.
Thank you, sir. Thank you, sir.
Dr. Sabu Thomas has joined us. Good evening, sir.
Sabu sir, good evening.
है ना खोला जाता है ना
Sabu sir, good evening.
वेरी गुड इवनिंग एंड टर्न आयो
Yes sir, yes sir.
कैन आई स्टार्ट
No sir, just after welcome sir.
या थैंक यू
Yeah. Malini.
Respected elders and all my dear, very good friends and participants, we move on to the last segment of the 7-day FTP program. I invite Dr. Lakshmi for the prayer.
Am I audible?
Yes, you are, ma'am.
In the quiet of this sacred space, We gather here in love and grace. With hearts open, we humbly pray. Guide us, Lord, through each new day. Oh, source of light, oh, guiding star, guide us, Lord, from near to far. In your embrace, we find our way. In your love, we humbly stay. In your love, we humbly stay.
Thank you, Dr. Lakshmi. I now invite Dr. A. Pramila Gnanasoundari, Research Scientific Officer at RVS College of Arts and Science, Coimbatore, to welcome the gathering. Ma'am, over to you.
Yes, ma'am. Thank you. Good evening to one and all present here. It gives me immense pleasure to extend a warm welcome to each one of you at the validity session of this 7-day online National Faculty Development Program on Emerging Trends in Intellectual Property Rights. As we gather this evening, there is a distinct sense of accomplishment reflecting on the week gone by, a week of learning, sharing, and illuminating discussions on the multifaceted dimensions of intellectual property rights. I would like to take a moment to recognize the presence of our esteemed guest of honor, Professor Sabu Thomas, Chairman of Trivandrum Engineering, Science and Technology Research Park, and former Vice Chancellor, MG University. Sir, your contributions to the academic world is monumental, and we are honored to have your grace this occasion. A warm welcome to you, sir. I would like to welcome Dr. Sister Beena Jose, Principal, Vimala College Autonomous, Thrissur, Dr. R. Rajendran, Professor, Department of Biotechnology, PSG College of Arts and Science, Coimbatore, and Dr. T. Shivakumar, Principal, Ratnavel Subramaniam College of Arts and Science, Coimbatore. Your energizing words during the inauguration session have set the tone for our week's program, and we eagerly look forward to hearing you from again. From the foundation structures of intellectual property laws to the intricate nuance of patents, trademarks, GIs, IP protections, and beyond, our resource persons have dwelled deep, and their insights have sparked a newfound passion among our participants. Our heartfelt gratitude goes to all speakers and resource persons. Special mention to the team from Inter University Center for IPR Studies, CUSAT, coordinators Nirmala College Autonomous, Thrissur, and RVS College of Arts and Science, Coimbatore, for their invaluable contributions. I welcome you all to this function. A program of this magnitude could not have been possible without the support of every single individual involved. From our technical teams ensuring smooth online session to our coordinators working tirelessly behind the scenes. To our participants, your engagement, queries, and feedback have been the driving force. I extend my heartiest welcome to one and all. In closing, I once again welcome each one of you for this valedictory function. Let the deliberation of this valedictory session add the perfect finishing touch to our week-long journey. Thank you for the opportunity provided. Once again, I welcome you all, and let's have a memorable valedictory session ahead. Thank you.
Thank you, Dr. Pramila. I now invite, with a lot of honor, Dr. Sister Beena Jose, Principal, Vimala College Autonomous, Thrissur, for the presidential address. Sister, over to you.
Oh, give thanks to the Lord, for he is good. His steadfast love endures forever. Most respected Professor Dr. Sabu Thomas, Chairman, Trivandrum Engineering, Science and Technology Research Park, and former Vice Chancellor of MG University, Kottayam. Professor Dr. R. Rajendran, Associate Professor, Department of Biotechnology, PSG College of Arts and Science, Coimbatore. Dr. T. Shivakumar, Principal, RVS College of Arts and Science, Coimbatore. Dr. R. Dhanabalan, Coordinator of DBT Star College Scheme, RVS College of Arts and Science, Coimbatore. Dr. Sister Sylvie Matthew, Coordinator of DBT Star College Scheme, Vimala College, Thrissur. Organizing Committee and Technical Committee members. Participants from various institutions across India and my dear colleagues. Today, we come to the end of the 7-day national level faculty development program on emerging trends in intellectual property rights, jointly organized by Vimala College, Thrissur, in collaboration with Indian University Center for IPR Studies, KISAT, and RVS College of Arts and Science, Coimbatore. It is our proud privilege and honor to associate with them, and words of gratitude to all the collaborators who have joined with us on this venture. Intellectual property is often referred to as the lifeblood of innovation, and it is the driving force behind progress, sustainability, and human advancement. I'm sure that the 7-day faculty development program offers an exemplary platform for all of us to interact with the expert and gain a deeper understanding of the intellectual property rights. Eminent resource persons and vibrant participants across India made this FDP fruitful and productive. The constant support and encouragement from Professor Dr. R. Rajendran, Associate Professor, Department of Biotechnology, PhD College of Arts and Science, Coimbatore, Dr. T. Shivakumar, Principal, RBS College of Arts and Science, Coimbatore, provided an impetus for the smooth conduct of this program. I would also like to mention about the keen attention and active involvement throughout this program.
Rajendran,
I express my deep sense of appreciation to Sister Tessina P. Inmati and Dr. Malini K. Vice Principals, Dr. Sister Sylvie Matthew, the Coordinator, and committee members of Vimla College for organizing such a marvelous FDP program. They worked hard day and night, and during these days to make this program a grand success. I'm also glad that 200 participants from 7 states across India, Andhra Pradesh, Karnataka, Maharashtra, Rajasthan, Telangana, Tamil Nadu, and Kerala participated in this program. We are very glad and proud to have all of you as our fellow travelers on this journey of 7 days FDP program, which we hope that you will cherish for the rest of your life, and let us also continue to collaborate in the future. I wish all the participants a bright future and God's blessings in the journey ahead. Thank you.
Thank you, dear sister, for those most enlightening words. It is my proud privilege to welcome Dr. Sabu Thomas for the valedictory message. Professor Sabu Thomas, Chairman, Trivandrum Engineering College of Science and Technology and Research Park, former Vice Chancellor, MG University. Please, sir.
very good evening to all of you. Can you all hear me?
Yes, sir.
Yes, sir.
Very
Yes.
good.
You're audible, sir.
Very good.
Yes, sir.
The principal of the college, Vimla College, one of the prestigious colleges in the state of Kerala, and we are very proud of your college, sister. The PhD College faculty member, Dr. Rajendran, Dr. Matthew, DBT Star College coordinator, and also the faculty from RBS College, Coimbatore, and all the experts, faculty members, participants, all my colleagues. Let me first congratulate the Vimla College, particularly principal and the team, in organizing a very exciting program on intellectual property rights. My special congratulations to all of you. The KUSAT resource persons. KUSAT is doing a wonderful job. The IPR studies of KUSAT is doing a wonderful job. They have come to my campus and conducted many symposia and conferences. And all the partners of this meeting, I congratulate. Let me start with a very important experience of mine. I think almost 10 years ago, dear colleagues, friends, we had a speaker from United States, University of Akron, Institute of Polymer Science. That is, the University of Akron is the rubber center of the world, one of the top institutes in rubber science and technology. A faculty from University of Akron came to Mahatma Gandhi University. His name is J.P. Kennedy. Kennedy is now 93 years old. When he came to my campus, I think he was 80 or 82. And he stayed with me for a week in the university campus. And he delivered a series of lectures. He's a synthetic polymer chemist, well known worldwide. In one of his talks, he specifically focused on IPR patents. In his talk, you know what he said to all my researchers, to all my colleagues. That's a very interesting speech he made. And he made a very important remark. You know what he said? If you find something interesting in your laboratory, when you do laboratory work for PhD students or postdocs or master students, when you do new experiments in the laboratory, if you do something very interesting which are scalable, Professor Kennedy said, don't publish, dear colleagues, don't publish immediately. You file a patent. Then he said, don't stop there. After patenting, don't stop there. He said, you should incubate it. Scale up. Again, he said, don't stop there. Develop a startup. Again, he said, don't stop. Startup has to grow. Develop into a company and spin off. Then he also mentioned after patenting, you publish in a high impact journal. That was something remarkable what he said. And Professor Kennedy has almost 100 companies. In the United States, faculty members can run companies. A professor running many companies. And he had a large number of patents. So dear colleagues, friends, students, my message is, if you find something interesting, I also request Vimala College principal as well as my co-worker Gigi, if you find something interesting, you go for a patent. And I want the principal, your patent should be extremely active. You should support the faculty members and try to file a patent. And you should also inculcate the spirit of writing patents. I would recommend give a coursework, how to write a good patent. Very important. Let me also tell you, if you look at Korea, we had a Korean professor to the campus a few weeks back. In his talk, you know what he said, something very interesting. He made a very nice, interesting table in his talk. And he said, look at Korea. The statement he said, look at Korea. We file almost 6,000 patents for 1 million population, that he said. And he said Korea is #1 in the world in filing patents. Korea has beaten United States, Korea has beaten China, Korea has beaten Japan. And I asked why, how do you do that? He said, our patenting process is very active. Students have really coursework how to write a patent. And dear colleagues, friends, the state of India is not very interesting even now. If you look at the international statistics, the number of patents for 1 million population is something like 60 or 70 for India. That's not enough. Look at Korea, more than 5,000 patents for 1 million population. So I congratulate IPR studies of Cochin University going to Vimala College, conducting a very nice workshop on IPR studies, intellectual property rights. And my request to all the participants, what you have learned from this workshop, this FDP, almost a week of FDP, what you have learned from this workshop, try to assimilate with your colleagues. Try to assimilate this with your students. Let them learn about it. And I again repeat the words of Professor J.P. Kennedy from University of Akron. If you find something interesting in your laboratory, don't publish immediately, go for a patent. And I also remember a few years ago, I went to Stanford University. And I had a meeting with the president of Stanford. I posed a question to him. Dear President, how do you maintain your world ranking? You see, if you look at the world ranking, where QS ranking or Shanghai ranking or Times ranking, Stanford is always within 5 world ranking. I posed a question to him. Dear President, how do you maintain such a good ranking? You know what he said? He went to the window. He called me Dr. Thomas. He indicated, look at the Silicon Valley of the United States. Silicon Valley of the United States, he just pointed out the product of Stanford, he said. And he continued. He said, in 1800, Stanford was nowhere. He used the term Stanford was a secondary engineering college. That's the term he used. And now Stanford is within 5 world ranking. You look at any subject, Stanford is top. And he said this is because of startups. And he again continued, startups are the engines for wealth, employment, and development. So dear colleagues, friends, students, if you find something interesting, don't lose your IPR rights. Go for a patent. And if you take 100 patents, maybe 3 or 4 could be successful. Even then, it's very important that we file patents. And patents should be eventually converted into a sort of industry or spin-off company. That's very important for industrial development of a country. I wish all the best for this meeting. And I congratulate the principal and the faculty members organizing such a beautiful workshop on FDP on IPR studies. And I am now heading, probably you know that I'm now heading Trivandrum Engineering, Science and Technology Park. And our mission is strengthen industry-university interactions. Within a week, I'm going to have a brainstorming discussion meeting with all the college faculties in the state of Kerala, university faculty in the state of Kerala, how we can interact, how we can collaborate. And my vision is transform the Trivandrum Engineering and Research Park like Silicon Valley of the United States. That's a dream of our CM. And I request all your active support and participation in this venture. Wish you all the best and good luck. And I'm really happy to cooperate and collaborate with you. Thank you so much. And wish you all the best for this FDP program. Thank you.
Thank you so much, sir, for those beautiful, enlightening words of wisdom. Before we move on with the responses from the participants, I must remind all the participants that we have an examination, an MCQ examination, which you will find posted in your emails and also in the WhatsApp group. You will have 2 hours to attempt this examination. Okay. So, and this examination, the MCQ examination, is very much mandatory for the successful completion of this 7 days FDP program. Shall we move on to the response from the participants? May I invite Dr. Senthil, Professor, Department of Botany, St. Joseph's College, Trichy, Autonomous, for the response. Sir?
Yeah, good evening. Thank you very much,
Senthil,
sister.
sir?
Yeah, good evening, sister.
Over to you.
Yeah, good evening, sister.
Yes, sir. Good evening, sir.
Yeah, IPR, which allow us to build and strengthen our brand, but securing IPR rights, which can be very sometimes expensive. It's practically. But Professor Sabu, during the valedictorian address, explained very clearly what are the difficulties, what are the challenges, how the South Korea is very promising with this IPR and all. Very clearly, Professor Sabu explained and all. But I have, that as when you go for IPR, there are many advantages. And at the same time, there are many cons also there, especially the cost and the pirating and the quality and all. These are the past 7 days lectures, especially related to IPR introduction, copyright, inventions and the GIs, the trademark, IPR laws, the biodiversity and farmers, and all very useful lectures. There is no doubt in it. It's a few remarks, but any program, there will be a few remarks, which is not for give anything negative impact about the program, but which will improve us, which help us, especially the participant side. A few things, that is the time slot, which is some of the sessions which are not completed fully are engaged. So that I felt one part. And the second part, the patenting filing difficulties. Many of the professors, we know that a few basic information theoretically, but the difficulties, how to file and what are the difficulties you are facing, because it's not much easy to file Indian patent. I have very long back I filed the Indian patent. I struggled more than three to four years. The problem with either with the lawyer or either with the patent office, just a blank. So that part which is lacking here. And the third part, the scholars, which a few scholars, which is not because this is fully faculty, but instead of faculty, scholars could be also included in near future because they are the futures. According to that, they plan how to patent their research work, how they do innovatively, and all the part of the IPR. So these are a few part from my side. And above all, this 7-day online the National Faculty Development Program on Emerging Trends on IPR, which organized by Vimala College Autonomous Thrissur in collaboration with the officials of CUSAT and RBS College Coimbatore. But really, special note of thanks to Sister Bina Joseph, principal of Vimala College. We had also MOU with Vimala College. It's a wonderfully planned everything. And our special appreciation to Sister Sylvie Matthew, the coordinator of the program, and all organizing committee members of the department, and all other organizers from the CUSAT or RBS College. The special thanks to them on behalf of the participants. The safety program is very illuminating and very useful by many ways. I hope that many of the participants which get benefited out of these lectures. On the behalf of the participants and my own behalf, we express our gratitude to everyone, because organizing a program for 7 days is not much easy, because your sister mentioned after the daytime we have a college and responsibility, and evening time we are sitting with up to 9 o'clock, and both the participants and as well as the organizing group is a very task force one. But anyhow, we express our gratitude to every one of the organizers that for all the arrangements promptly have a detailed sister. Hope to have many more programs near future, and good luck to everyone. Thank you very much for sister for all the arrangements and for the opportunities given to me. Thank you very much.
Thank you, sir. Before we move on with the other responses, may I please request all of you to on your videos for a group photo of the FDP, for an official photo of the FDP. Please, let's have all the videos on. Participants, elders, respected colleagues, please, all the videos on for the official photograph. Thank you so much. Shall we move ahead with any more responses? Anybody who would like to pose their responses here in the group? You're most welcome to do so now. In the meanwhile, let me once again remind you about the MCQ examination and the feedback links posted in the chat box, which are mandatory for the successful completion of the 7 days National FDP program. Anybody else who would like to go ahead with the responses, dear friends?
Can I just have 1 or 2 words here? I would like to thank the entire organizers, both colleges, and all faculty members involved on behalf of
we are done.
University.
So let me now invite Dr. Sylvie Matthew.
Yes, Mallika ma'am, Kavita ma'am.
Yes, ma'am. Please go ahead.
Yeah. So thank you so much, everyone. It was a great opportunity. And although all the resource persons are not there, I hope, I'm speaking on everyone's behalf. It was a great opportunity for all of us, and we also look forward to further collaboration. And as Senthil sir said, I would like to say that acquisition of IP, that is acquisition of patent, registration of copyright, registration of trademark, it falls within an entirely different ambit, and it would take another 7 days to cover, because each of these categories would require 1 or 2 hours to at least discuss the basics. So maybe in the next year, IFDP on IPR, maybe you could think about acquisition of IPR specific for academic sector. We don't have to go for other sectors. But thank you everyone. Thank you, Sister Beena. Thank you, Sister Sylvie, and thank you everyone for giving this opportunity. And I think the Coimbatore College also had, they had also contributed a lot. What I found very different in this particular FDP. Usually we take a lot of classes, but it is very rarely that participants ask a lot of questions at the end of the session. So plan variety is one of the what we say driest IP, because unless you discuss cases which is not relevant, which is not that relevant for this session, unless those are brought in, this is a dry subject, but still all 80 of them were till the end of the session. That indicates their commitment and enthusiasm. So thank you everyone for participating. I mean, it's not just organizing. Sister Beena would know, because without participants, the FDP is nothing. Without their constant and continuing presence, it's not nothing. Thank you everyone for being a part of this program. And we wish you every success in all your academic endeavors and your personal happiness. Thank you once again on behalf of IUCI PRS and on my own behalf. Thank you.
Thank you so much, ma'am. Shall we move on with the vote of thanks, sister? Okay.
Yes,
So
ma'am.
now let me invite Dr. Sylvie Matthew, the coordinator of the Star College Scheme, DBT Star College Scheme, Vimla College Autonomous Thrissur, to render the vote of thanks. Sister, over to you.
Yes, ma'am. Am I audible? Am I audible, ma'am?
You are, sister. Please carry on.
Yes, sister. Yeah.
Honorable Chief Guest, Dr. Sabu Thomas, and present excellencies and all. A very good evening to one and all. The 7 days faculty development program on intellectual property rights conducted by Vimla College Autonomous Thrissur, supported by DBT Star College Scheme, Department of Biotechnology, Ministry of Science and Technology, Government of India, in collaboration with the India University Center for IPR Studies, Cochin University of Science and Technology, and RVS College of Arts and Science, Coimbatore, has come to a successful end. I consider it a great privilege to propose the vote of gratitude on this occasion to all the dignitaries who have graced this event with their presence and participation. The success of all events is impossible without the grace of Almighty. Let me begin by giving glory to the one who makes all things possible, whose blessings this FDP has had. First of all, I would like to thank our chief guest, Professor Sabu Thomas, Chairman, Trivandrum Engineering, Science and Technology Research Park, and former Vice Chancellor, MG University, who graced us with his thought-provoking valedictory address and set a perfect platform for our future events. We are really enlightened with your knowledge and presence, sir. Thank you, sir. The successful conduct of this FDP actually happened because of the interest of a great personality, Dr. Rajendran R., Associate Professor, Department of Biotechnology, PhD College of Arts and Science, Coimbatore, for kindly accepting our invitation and gracing the inaugural function of this FDP on 14th August. We are very grateful for continuous support and advices which have greatly helped in the successful organization of this FDP. So on behalf of Vimla College, I extend my heartfelt thanks to Dr. Rajendran in his absence here. We are also very thankful to Dr. T. Shivakumar, Principal, RVS College of Arts and Science, Coimbatore, our collaborating college in the successful coordination of the FDP. Thank you, sir. I would like to acknowledge the unwavering support received from our principal, Dr. Sister Beena Jose. We are continually impressed by her ability to unite our campus community. She has always fostered a sense of support and appreciation that allows us as educators to improve our practice daily. We are forever grateful for all you do. Thank you, sister. Thank you. Also, we extend our gratitude to Cochin University of Science and Technology, who accepted our invitation and also gave a collaboration with the FDP. I convey our special heartfelt thanks to the all administrative team of Cochin University of Science and Technology. Thank you all. This FDP gave us the opportunity to interact with many eminent personalities. From the first day itself, we have listened to various aspects of intellectual property rights. We express our sincere gratitude to a galaxy of resource persons from the Inter-University Center for IPR Studies, Kochi University of Science and Technology, Dr. Kavitha Chalakil, Assistant Professor, Dr. Asha R, Research Officer, Dr. Anson Joss, Assistant Professor, Dr. Vishnu Shankar P, Assistant Professor, Ms. Arathi Ashok, Assistant Professor, School of Legal Studies, and Dr. Chaitanya EP, Assistant Professor, SN College, Natika, Tripura. They have handled successfully the following topics like introduction to intellectual property law and patent law, introduction to copyright law, patenting of biotechnological inventions, protection of geographical indications, protection of trademark, intellectual property laws and biodiversity, and plant variety protection and farmers' rights. We are indebted to each one of them. Thank you, Kavitha ma'am, and thank you all my resource person. Thank you all. I would like to acknowledge and thanks to our vice principals, Sister Tessina P. Immati and Dr. Malini K.A., who have provided guidance and constructive comments to deliver this FTP in a fruitful manner. I would like to extend a heartfelt gratitude to Dr. R. Dhanabalan, DBT Star College Scheme Coordinator, Department of Microbiology at RVS College of Arts and Science, Coimbatore, and all department coordinators of RVS College for their kind cooperation and participation in this FTP. Thank you all. Thank you. I believe this is the right moment to acknowledge creative inputs provided by our participants who came from different niches of the nation for their kind cooperation, participation, and making the FTP as a successful event. Especially, I am very grateful to Dr. Sendil Kumar for his response, and we are thankful to all of you for your enthusiastic and meaningful participation in the FTP. Thank you all delegates. We have been fortunate to be supported by a team of very active and dedicated coordinating team and technical team of Vimala, including Dr. Hani, Dr. Sheja, Dr. Mini Krishna, Dr. Anjali, Dr. Gigi, Dr. Preeti, and our anchor Maliga ma'am, and all our joint coordinators who are well versed in their jobs and with a deep sense of appreciation. I would like to thank all staff members from RVS College of Arts and Science and my colleagues from Vimala College for their untiring efforts. Thank you all. Thank you. And also, I am very grateful to our technical team members of Vimala College for the successful event of this FDP, especially thanks to Albin and all. Once again, I would like to acknowledge and thank you all for conducting the inaugural valedictory and all technical sessions in a fruitful way. Thank you all. Thank you so much.
Thank you so much, sister. You have covered all of it. The nuance. They say, when we learn a little, we feel we know a lot. But when we learn a lot, we realize how little we know. So until we meet again in the infinite realms of academia, it is goodbye and good night from all of us at Vimla College. Yes, you will all receive your certificates in due course. Please do not forget to attempt your MCQ examinations posted in your respective mail IDs, the registered mail IDs. Please see that it is mandatory that you complete the feedback links as well as the MCQ examination so as to make yourself valid for it again. Have a beautiful night. Thank you, sister.
Thank you. Thank you.
Ma'am, when did we receive our e-certificate, ma'am?
Sir, within 2 days you will get.